Commission resumes. Mr. Mpofu, I understand one of your colleagues also wishes to participate in the discussion before Mr. Berger does. Mr. Mampela, are you going to do you wish to speak before Mr. Mpofu or after? You indicated to me during the German that you.
I think it should be before Mr. Mpofu, so that he can sweep any other thing I may leave out.
All right. Remind us for whom you are appearing.
Thank you, Chair. Rampela appearing for Mabebe family and Mabelani family.
Yes. Thank you.
Chair, as I have indicated, the Chair will excuse me if I actually become a bit out of order because I've been out of the Commission for some time. Just that I think this issue of Phase 2 is quite critical, and I would like to make an input on it, because in my view, it would be very sad indeed, and I agree with my learned brother, Advocate Nzabeza, that the actual causes of Marikana are actually in Phase 2. Who and how so-and-so was shot is more something that one could, it's the effect. And I believe that some of the issues that are important are issues relating to how the police, and that is why I think not only Lonman is important in Phase 2, but how the police, or how as a country we have managed to transform our police from a force into a service. Throughout the Commission, we've not really dealt with the community participation in the policing. So the issue of community policing forum, the manner in which this whole thing was approached, including important stakeholders, as to how AMCU was involved in the policing, how NUM, whether there was any forum where the community could have been involved. So all of these, I believe, are Phase 2 issues that are critical and that may actually assist us to avoid another Marikana in the future. The second issue that I think is important, and that is why Phase 2 has to be looked into, is an issue that we raised during cross-examination but did not really go into. And that is the issue of corporate governance, not only of Lonman but generally, and the involvement of an important stakeholders in corporate governance in the South African mining industry, especially because as if one reads the evidence of the Costa, this was a situation, and this is in re-examination by Mr. Berger SC. This is a situation where there was probably anarchy that was going to ensue. And this, from the evidence one gathers, was a decision taken by an executive and probably a board on the one side, with an important stakeholder in the industry being the unions, the workers, and the final decision on the issue, one not knowing what the other has actually taken a decision on, and almost a wall having been built amongst or between the two disagreeing parties. So I believe that Phase 2 has to also look at these kind of issues. The other reason why I concur with the evidence leaders, as well as the suggestion by Advocate Nzabeza, is in our interaction with some of the community members in Bapong, actually I have documents of about more than 150 young people who said that they made an application to loanmen. And some of them were young mothers who were entitled to social grants. But after the application was made, they were registered by the department as employees of loanmen. They were just applicants, probably having gone through a fitness test, but not employed. And yet, this phase where probably the applications were being considered was given as information to other stakeholders, including government, as these people being employees of loanmen. Now, how loanmen as a corporate entity in South Africa dealt with their complaint is an issue that I think has to be ventilated, if not by this commission, then, as Advocate Nzebeza has said, by a body that the Commission can suggest in view of the time that this Commission has. So I believe, and the Chair has noted in my cross-examination that I said that death by hunger is more painful than being shot at. And the second phase is about those kind of issues. And those are the issues that actually led to Marikana. And I think those are the issues that this commission has got a very historical opportunity to actually say something about and address for our posterity. Thank you, Chair.
Thank you. Yes, Mr. Mpofu.
Thank you very much, Chairperson. Chairperson, I'd just like to start by saying the reason why I could not place myself on either side of this divide is exactly because I either agree with everybody or disagree with everybody. The issue here, Chairperson, is quite simple. It's a question of practicality. Loanmen, in their letter, say the following, that they consider the scope of the Commission's mandate and explain why to now embark on phase 2 inquiry is impractical and might well fall outside the mandate of the Commission. We obviously differ with them very sharply on the second part of that sentence. The inquiry into phase 2 obviously falls into the terms of reference. But on the first leg of what they say, which is that it is impractical, we agree with them very much. Chairperson, I'm just going to make 5 or so points. The first one is that our position on this is, even if I say so myself, quite nuanced and in a way complex. Firstly, it cannot be denied that the events which occurred on the 9th to the 16th of August had underlying causes, going back to the discovery of diamonds and gold in the 19th century, arguably up to 1652. For example, Chairperson, the migrant labor system is obviously directly related to the issue of housing, which is raised there, and the insufficiency of the money earned by loanmen workers. Hence, they are resort to unscrupulous money lenders and machonistas. And nobody is denying this. I don't understand loanmen to be denying this as well. So the issue of relevance, it doesn't even arise. It's relevant. It's pertinent. I think on that we are all on the same side. What is in contention, Chairperson, is whether these underlying causes, known as phase 2 in the Commission's parlance, can be properly ventilated in a commission of this kind, and more specifically, their causal connection to the massacre and related events. In all honesty, Chairperson, and for completely different reasons, we agree with loanmen that no justice can be done to such an inquiry in proceedings of this kinds, and more specifically in this commission, which is by its very nature necessarily so legalistic in its approach, since it is partly aimed at identifying wrongdoing, among other things. So our approach, Chairperson, is simply that the present...
Are you saying that the President erred in including what amounts to Phase 2, the Phase 2 issues, in our terms of reference?
No, Chairperson, in
because
the following...
we're a legalistic body, judge presiding, senior counsel, the two other commissioners.
No, Chairperson, no. And that's where the nuance is. Because, remember, I'm saying those issues are relevant. So, inevitably, it can hardly ever be expected that the Chairperson and the commissioners are going to say, look, the only issues, that, as you correctly pointed out in your exchange with Ms. Rue, the Chairperson can't say, look, we're just going to close our eyes and start on the 9th up to the 16th. Or at worst, we'll start with Mr. Da Costa and stop on the 16th. Obviously, even the witness that I've just called now, Chairperson, has given evidence, Mr. Mchamba, about, for example, he says apartheid still exists at Lonmin. Those are the wider issues. So they are relevant to your inquiry. And indeed, we, of all the parties, have canvassed those issues with many witnesses, with Mr. Ramaphosa, with our own witnesses, and so on. So they're certainly relevant. However, the question is whether well, let me put it this way. We say that the Commission must concentrate on the Phase 1 issues, and I'll explain why we say that. Which answers your question. This is not to say that it cannot mention and refer to the underlying causes, the Commission, insofar as evidence has been laid in relation thereto, or insofar as these issues have been referred to in the seminars and so on. And as I say, many witnesses have given evidence relevant to these issues, including Mr. Makidwana, Mr. Pasha, Mr. Da Costa, Mr. Ramaphosa, and Mr. Mchamba, as I've just mentioned. However, if justice is to be done to the issue of the underlying causes, then a separate and different inquiry, and this is what Mr. Ntsebezo was alluding to, I was going to address, must be done. This must be a commission much like the one I can think of is the Vihan Commission. That type of commission, not this type of inquiry, which is A, not time-bound, B, not adversarial and dominated by lawyers, but other types of professionals and academics, economists, and so on, who can delve deeply into these underlying issues. The weakness of the present inquiry is that some of the witnesses, quote unquote, who might have played like Cecil John Rhodes or whoever who started the mining industry, cannot be called, and Lonmin cannot be expected to answer for them. And in fairness, Chairperson, if this, and that deals with your direct question, if what I've just said calls for a belated amendment of the terms of reference, well then so be it. The issue, Chairperson, is that in the 6 weeks that remains, no justice can be done on these issues, and the danger is that if they are dealt with superficially, then everyone is going to relax, as Mr. Ntsebezo alluded to, and assume that, oh well, it was dealt with, it's done now. The answer, we think, lies in paragraph 5 of the terms of reference, which reads as follows. The Commission shall, where appropriate, refer any matter for prosecution, further investigation, or the convening of a separate inquiry to the appropriate law enforcement agency, government, department, or regulator regarding the conduct of a certain person or persons, unquote. This section, I had a debate with 2 of my colleagues in the morning about it. And I think it has been incorrectly and narrowly interpreted to mean that it only refers to prosecutions. That is not my reading of the paragraph. It says, Commission shall where appropriate refer any matter for prosecution, further investigation, or the convening of a separate inquiry. So it's not confined to matters of prosecutions. It also envisages further investigations and the convening of separate inquiries. And there are many bodies. Well, I would agree with Mr. Malenfre and Mr. Nsebeza that since the chairperson is well steeped in the issues, he might, if he were available, he might well be the appropriate person to do it. But there are other institutions in South Africa, constitutional institutions, which deal with these broader human rights issues that are envisaged here. So, in short, Chairperson, our position is motivated by the belief that these issues are too important, rather than to say they are unimportant. And if I can just quote one example which has been cited here. We believe very strongly, as Mr. Ncukaitobi alluded to, that Shanduka's acquisition of the broad-based BEE deal, which included the workers, and when they took that deal, they narrowed it down to a few individuals. That had that not been done, then the massacre might not have happened. Because remember, Chairperson, that if the workers had a stake, as they did before the Shanduka takeover, then their own disposition at the copy, in fact, they probably would never even have gone to the copy for starters, would have been different. But more importantly, Chairperson, just like Shanduka, they would have had a representative on the board of Lonmin, directly or indirectly. And surely that person or persons would have said, just go and talk to them, or I'll go and talk to them, or whatever. So those issues, it goes back to your earlier question, Chairperson, are clearly relevant and may or may not be, depending on whether we argue this successfully, be causally connected to the actual incident. But they need to be delved into very properly. We need to sit here and analyze those shareholder agreements. I think Mr. Ramaphosa, in fairness to him, even considered that they themselves are looking into broadening, if there's such a word, that empowerment deal, which is a concession that shows that the current structure is deficient. So those issues are definitely important. And it is exactly because they are very important that we say they can be dealt with in the remaining 6-week span of this commission, or no justice can really be done with them, in dealing with them. So we say this is one situation where the adage, half a loaf is better than no bread, does not apply. We'd rather have the whole loaf, and we'd rather have it done separately and without detracting from the important answers that are required by the people we represent. Want answers. Obviously, like all South Africans, they want answers to the underlying issues, but primarily they want answers to what happened, which led to the specific issues that are dealt with in phase 1. And we cannot compromise those answers at the expense of the wider answers that we all need. And in fairness, Chairperson, you know that we've taken a stance that's very adversarial towards Lonmin. But why must Lonmin be visited with the sins of the whole industry? Why? Just because they happen to be a party here in these particular proceedings. If, for example, what Mr. Mchamba is saying, that apartheid still exists at Lonmin, then I can put my last dollar that it's not just at Lonmin. It might be right across the entire industry. And we cannot therefore expect the one party that happens to be here in front of us to then be answering for the sins of the industry and successive governments of the past which may have colluded with capital. To do so would be the same. It would be like asking SABC to be answerable for the Rand revolt and of the 1920s and the massacre in Sharpeville and this one and that one. We can't. What we are here to look at is the specific, what we've called the specific collusion between Lonmin and SAPS in relation to this particular matter, not the general historical sins, as I say, of either SAPS or Lonmin, which cannot be visited upon one company that just happens to be the one in front of us. Thank you, Chairperson.
Thank you. Yes, Mr. Berger.
Chair, we made written representations at the invitation of the evidence leaders in a note of the 27th of July, which we received from the evidence leaders. They said the following. I unfortunately don't have copies of these, but they're on record, and if I may read them into the record, it will be brief and it may facilitate the process.
Yes, of course.
They said to us, and I read selectively.
If it's relevant, we can put copies in as Exhibit quadruple N3 if you desire that.
They wrote to us and said, in relation to oral evidence on Phase 2 issues, the evidence leaders are of the view that the ruling separating Phases 1 and 2 should be withdrawn now that most of the issues originally to be canvassed in Phase 2 have been removed from the Commission's terms of reference by the deletion of Clause 1.5 of the original terms of reference in Proclamation so-and-so. Most of the remaining issues that were originally to be addressed in Phase 2 are issues relevant to the responsibility of Lonmin for the Marikana tragedy. Some of the Lonmin executives who will be called to testify in relation to Phase 1 issues are witnesses with whom the evidence leaders would like to canvass Phase 2 issues relevant to Lonmin. And then the note concluded thus: the evidence leaders have accordingly approached the commissioners to withdraw their original ruling separating the hearing on Phases 1 and 2. Any parties who want the original ruling to remain in place are invited to address written submissions to the commissioners on or before the close of business on a certain date, and that date was extended, and we then filed our written response, which is now quadruple N1, and we wrote at the end of that to say, should the Commission be inclined to revoke the earlier direction that Phase 1 be addressed, we would urgently request the opportunity to present oral argument in open commission to explore further the issues which have, due to time constraints, been referred to above. And that's why we're here today. The issue is narrowed now. This is not an issue as to whether you should abandon Phase 2. You cannot abandon it, that's your mandate. It's also not an issue anymore as to whether those remaining issues to be inquired into in the context of Lonmin should proceed as the issues for the next 6 weeks. The issue now is a very narrow one. It is, should Phase 2 be introduced into this Commission on Chapter 5 of the interim report, whether Lonmin has complied with his SLP obligations. That's the issue. So it's not surprising today that all my colleagues argue for an opening up of the inquiry, and Lonmin is the only side saying, do not open up. But, Chair, you would have heard the discomfort with Mr. Nzabenza. He's clearly uncomfortable with this because he says, you inquire into this, but this is not Phase 2. This is a component part of Phase 2. So what he suggests, as I understand him, and I don't want to do him a disservice, he says, start on this partial inquiry. You're not going to finish it, and then make a recommendation that somebody else should pick it up and complete it in its enlarged form. Well, that's really a scenario too ghastly to contemplate. My learned friend, Mr. Mpofu, has got the same discomfort. He sees that to now inquire into the housing of Lonmin doesn't serve his purpose, certainly. He wants to inquire into Sanduka. He wants to know what happened to the deputy president of the country. He's got other fish to fry. So this is not going to work, but in fairness, he does say this. He says, why single out Lonmin and their housing obligations under SLP and convert phase 2 into that? Well, there's no answer to that. That's unfair. It's outside the mandate we will submit, and it shouldn't be done. Why should Lonmin be singled out on this debate? But I'm running ahead of myself. I'm explaining why I'm alone in opposing the introduction of phase 2 now. We will make 3 fundamental submissions with your permission, Chair and Commissioners. First is that Lonmin's housing obligations fall outside your mandate. Secondly, that probing Lonmin's housing obligations in the context of the SLP in a vacuum is not meaningful. What I mean that is, you can't probe that without looking at the municipality, the province, the government, education, sanitation, clean water, the whole array of social ills. You can't do this piecemeal. You either look at it...
Sorry, what is the relevance in regard to the simple question as to whether Lonmin complied with its legal obligations, which it voluntarily assumed, on the strength of which it got its new order mining rights? What is the relevance of possible failures by other bodies to comply with other obligations of theirs in the housing area?
That inquiry is not in the mandate of the Commission, with respect. The Commission's mandate...
No, I understand that.
Yes.
But what I'm saying to you is, if Lonmin's failed to comply with their obligations, if they did,
yes,
legal obligations,
yes,
the non-compliance with obligations by other bodies would have no relevance to that. They can't put up as an excuse, we didn't build houses because other people didn't build houses. Sorry, can I finish? If their breach of those obligations led to their workforce being obliged to live in conditions of squalor, which even the former non-executive director, Mr. Ramaphosa, conceded could lead to trouble. There are other statements that have been referred to by Lonmin officials saying that this was a ticking bomb and so on. Whether there is a causal connection, of course, is a matter which would arise for consideration under the proposed inquiry. But the point I'm putting to you is that if it is so that there may well be a causal connection between their failure to comply with their specific obligations and the creation of what amounted to a tinderbox, which led to the trouble which has brought us here. If that's so, how can it be relevant to say, well, they're excused, making all the assumptions against them, which may not be correct, of course, but they're excused because other bodies also failed? I don't understand the relevance of that submission.
No,
Perhaps you must explain it more fully to me.
I will in due course. I'm dealing with the second main argument. That is, one can't consider that in vacuum. The answer to the question you posed to me, Chair, lies in the first one on causation. But in the second one, it lies in this. It is unhelpful to probe, in the context of the deaths of the people in this inquiry, whether Lonmin had provided houses without at the same time comparing what houses were provided by the municipality, by the province. Could Lonmin provide houses if there was no sanitation? Could Lonmin build houses if there was no running water, and whose responsibility was running water? Could Lonmin provide houses getting 200,000 people in the Northwest Province from the Eastern Cape, seeing the educational infrastructure in that province? Is that feasible? It's not an isolated inquiry. It's a sophisticated, multifaceted inquiry, which falls outside of your mandate, because that's the first point. Your mandate is particularly linked to the events of a certain period of time. It's the only point I make on the second one. And the third main argument I want to address is that it would be unfair at this stage, 2 years down the line, 6 weeks to go, to start inquiring into this issue and to expect Lonmin alone to address that at this stage of the game. Those are the three main arguments, but let me make two observations by way of introduction. Firstly, Lonmin accepts that decent accommodation for all people living and working at Marikana is a priority. I'm not defending the squatter camps under the trees in that area. My client doesn't do that. If I may ask you to have a look at quadruple N2, which is the interim report, and you'll find the interim report, page 53. There is a quote from the Lonmin chairman of January of last year, where he said the following, and this is the attitude of Lonmin. Page 53 of quadruple N2. In the 1990s, Lonmin and other mining companies, in consultation with the unions and associations and with the approval of the Department of Mineral Resources, created a living out allowance scheme as a first step in moving away from the shared accommodation single-sex hostels in which most miners had lived during the apartheid era. An unintended consequence of the living out allowance was the many workers who chose to live in shacks close to the mines, either because they reallocated the allowance to other priorities or due to a lack of access to decent accommodation. Lonmin recognizes that it and the industry as a whole needs to rethink this approach. We must ensure that this unintended consequence is eliminated or at least minimized. Employees must have access to decent accommodation and the essential utilities of fresh water, proper sanitation, and electricity. That's a major debate, but that's not your debate, Chair. In fact, we have information that the Department of Mineral Resources statutorily assesses compliance with the mining charter. Given that the Charter's 10-year targets timeframe ends in 2014, all companies are to be assessed. The DMR has commissioned a consultant called Meloto Solutions to conduct an assessment of Lonmin's charter compliance earlier this year. That assessment will be completed by the end of 2014, and no doubt the DMR and the relevant authorities will have a look at that. That's not a debate for this commission. It is far too wide-ranging, as my learned friend Mr. Mpofu says. You need less lawyers and more experts in that type of a debate. But I'm still dealing with the preliminary statement to say Lonmin does not defend the unacceptable social conditions in the Marikana era. I want to quote a second example of that in that same report at page 56. I now quote the previous chair of Lonmin, January 2013, and in the middle of the last paragraph there, the interim report says, as Mr. Phillimore stated in his speech to the Lonmin AGM on 31st January 2013, Lonmin has a duty to its employees to ensure that they have access to decent accommodation and the essential utilities of fresh water, proper sanitation, and electricity. That my client accepts. So whatever I say today should be read against that backdrop. I want to make a second introductory comment, and it is this. Criticism of Lonmin for failure to produce documentation timeously has no merit. You would have seen that in the report, in page in the introduction to the interim report, on page 3 of triple N2, the second paragraph says, dealing with the production of documentation, the production of the Phase 2 report was impeded by the delays in obtaining information on Phase 2 issues from Lonmin. Ultimately, certain requests for documentation information which had been addressed to Lonmin since last year were only complied with in the last 2 weeks before the report was produced. That unfortunately obliges me to take you briefly through the history we all know. Chair, you will remember that in Rustenburg we had what we called pre-hearings. That was late in 2012 and early 2015. The pre-hearings were conducted by the evidence leaders to consider the preliminary list of themes for consideration in Phase 2 and for us to make submissions on those issues. Lonmin participated in that process. We gave a list of topics that we would not seek to address in Phase 2. We suggested that some of these things fall outside of your scope, and I think one of those was migrant labor, for example. That was too heavy a subject to introduce here, and we had that debate. And we then made the proposal that the ambit of all these topics be limited in scope by their usual connection to the deaths and injuries to persons and the damage to property during that period. That's going to be a theme through my debate because that's your mandate. You have to inquire into these things against the backdrop of those incidents. Following upon those pre-hearings, the evidence leaders did not respond to our proposal. That led to a further request for us in December, and in the end, on the 6th of March 2013, the evidence leaders reverted to my attorney with a rider that the topics to be identified will be limited in scope by their relevance to the death, injuries to persons, and damage to property at Lonmin's mining operation for the period 9 to 16, 2012. So far, so good. We're under the impression we're on the same page. In January 2013, Lonmin is informed of the appointment of Dr. Forrest. Sorry?
Must be January 2014.
2014,
She was
I'm
only
sorry.
appointed late last year.
14, and that's quite right. 14. And we are informed that she's been appointed as the Commission's senior researcher. She is in the process of arranging seminars and would like to be able to approach some of the clients of the parties participating to invite them to participate and to conduct interviews concerning some of the topics. And we're told that the commissioners would like to know if any of the parties have objections to Dr. Forrest doing so, and if the parties are agreeable to, whether they would like to suggest any protocols to be observed. We were then finished with a timetable for Phase 2, and it said, inter alia, the parties are to make discovery in relation to the topics which they propose to address, and in relation to any additional topics in respect of which they have been called upon to make discovery by the 18th of March 2014. This must be a typo there. But importantly, that timetable states the discovery obligations in paragraph 2 are subject to the following conditions. 1. The topics do not in any way supersede the terms of reference of the Commission. So a party is obliged to make discovery of documents in relation to a topic only insofar as the topic is relevant to the events in Marikana, which led to the death of approximately 44 people, and the rest we know. So we're still on the same page. It is still within the narrow confines of the tragedy of August. On the list of issues to be inquired into of particular relevance was issue 13. Chair, you may remember there were black typing and red typing. I don't have to go there, but black was 13, and one of the issues, Lonmin's obligations Point 1, the extent to which Lonmin complied with its social obligations under 13.1.1, the social and labour plan applicable to its mining right, 13.1.2, the mining charter, 13.2, the extent to which DMR took appropriate steps in relation to any non-compliance, 13.3, educational obligations of Lonmin. We then sought clarification of that from the evidence leaders in a letter on the 18th of February. And I'm going to read you the questions and the answers we got to explain to you what led to the discovery by Lonmin in March of this year. On the 18th of February 2014, my attorney wrote to the evidence leaders and said, when are these topics likely to be addressed and before which tribunal or body? The answer came back, the topics in black ink will be addressed before the Commission. This will be done when the evidence in respect of Phase 1 has been concluded. I read that again. This will be done when the evidence in respect of Phase 1 has been concluded. Brackets. One can, however, not exclude the possibility that some evidence relating to Phase 1 will become available and be introduced at a later stage, presumably after the Phase 2 evidence. The next question, when in the period between now and the end of April 2014, that's where we still believed that the Commission would terminate April 2014. When in the period between now and the end of April 2014 will these matters be addressed? The answer, it is not possible at this stage to answer this question. We hope that this will become clearer in the near future. The next question, skip one, to the extent that the matters are to be addressed, quote, fully, unquote, how many witnesses are anticipated to give evidence and what sources of information will the Commission rely upon to arrive at recommendations? The answer, the Commission will decide this in the light of all the information received by it. I refer again to a paragraph in another letter. Then 1.6, to which parties have these requests been directed? The answer, the list of topics with the invitation to submit relevant information has been sent to all the parties and to other persons or institutions. The Chamber of Mines had been invited. Like other parties, the Minister of Police has been invited to submit relevant information. All parties have been invited to submit relevant information on the identified topics. The parties include the Minister of Police, the SABC, the Department of Mineral Resources, the other institutions is entitled to participate. So at least we know now that Phase 2 is coming somewhere in the future and there are a multitude of parties who are going to make representations. In response to the invitation, and I must go quicker here because it's taking too long, my attorney writes to Dr. Forrest, they exchange views, and my attorney decides, instructs Lonmin, and Lonmin decides that we will not take part in the public seminars, simply because it's an open-ended debate, it is not structured, we don't think it's going to stay within the mandate of the Commission, and that's accepted. The seminars are held. I'm not sure all of the seminars planned were held, but some seminars were held, and Lonmin did not partake, and everybody knew that we were not going to partake. On the 18th of March, Lonmin made extensive discovery, and that, in fact, Chair, if I may ask you to consider that discovery, and you'll see that's really, it seems to me, the source of the interim report. You'll find that in quadruple N1, that's our written submission, and it's Annexure A to it. And you'll see, this is the discovery made in March of this year, under different headings, and I don't know how many files it were, but it must have been a number of files. Actual financial reports, the social and labour plans, that's where they come from. Section 3, sustainable development. 4, policy documents. 5, agreements. Land issues in Section 6. Housing in Section 7. Micro-lending in Section 8. These documents are produced. I have said to you that there was a decision taken by Lonmin not to take part in the public seminars. You'll find the justification for that in this same letter in paragraph 6.4. I'm not going to read it out, but there is with respect, a considered view why we thought that fact-finding mission was going nowhere. It's not going to assist the Commission, and it's not going to stay within the mandate of this Commission. Okay. Perhaps I should just read those 3 paragraphs.
I think you should.
Yes, I should. 6.4. Lonmin was also invited, says the letter, by Dr. Forrest to participate in what was termed the Marikana Commission of Inquiry Phase 2, underlying causes. Our client's response to this was conveyed in a letter to the evidence leaders on the 27th of March, and now I quote 3 paragraphs from the letter. The events which the Commission is mandated to investigate are causally linked to the tragic events at Marikana from 9 to 18 August, that should be 9 to 16 August 2012. The causal relationship between the matters to be investigated and the events to which they are linked provides the framework for the Commission's mandate. Having regard to this, our client is concerned that the seminars arranged under the banner of the Commission deal with topics which are open-ended and which may ultimately result in Phase 2 covering matters well beyond the ambit of the Commission's terms of reference. Our client's concern in this regard is exacerbated by the fact that the Commission has already run for a long time, at enormous cost, and with a significant time commitment. In this regard, our client's situation is not made any better by the fact that it is in the midst of a prolonged strike with enormous cost implications, which has fundamentally impacted upon our client's resources, both from a time and a financial perspective. In addition to the ambit of the topics which are identified for discussion in the panels, our client is also concerned about whether or not the matters identified for panel discussion can, having regard to the powers granted to the Commission and the duties visited upon the Commission, be, colloquially speaking, outsourced to panel discussions. The Commission's terms of reference require the Commission to investigate the matters which fall within its terms of reference, and also requires the Commission to inquire into and make findings and to report on and make recommendations concerning matters which fall within its terms of reference. There do not appear to be any powers granted to the Commission to appoint panel discussions for purposes of facilitating the work of the Commission. I must say, I don't know, and it may just be my ignorance, I don't know what Dr. Forrest's mandate was. Don't know who she spoke for, what she had to inquire into, and what recommendations she could make, but that may be a debate for another day. Yes. In fact, I've indicated that our stance of not taking part did not meet with any disapproval, as far as we know, from the evidence leaders or Dr. Forrest. Chair, at this time, and I'm still dealing with the criticism of Lonmin's delay, not only is Lonmin in the middle of a strike, but Phase 1 is putting a lot of stress on our resources. We started this trial, I was briefed for 2 months. It's now 2 years. We started with 5 counsel. We today have 3, and 2 of them are half. My learned friend, Mr. Bam, and I exchange seats on a regular basis simply because we can't be here all the time. So not only is there a financial constraint, there's a time constraint for the company. We're committed. He has done certain sections and I've done certain sections. And in that same process, we try our very best to assist the evidence leaders with requests which keep coming. They ask huge amount of documentation and we lean on our attorney and that's given. And if there's an opening in a week and there's no witness, we try to accommodate and we give witnesses. But we really work as hard and as diligently as we can to assist this commission in a spirit of cooperation. Then there's a request for further documents on the 12th of May 2014. Against this backdrop. In May 2014, the evidence leaders emailed my attorney to request certain information from Lonmin in relation to Phase 2 and pointed out issues which it would like Lonmin to canvass. In addition to this, the evidence leaders also sought information from Lonmin in relation to Phase 1 and commenced planning for Lonmin's Phase 1 witnesses to testify. The meeting held at the offices of my learned friend Mr. Bam and the evidence leaders, it was pointed out to the evidence leaders that it was going to be extremely difficult to accommodate expansive requests for information where Lonmin was still in the midst of a long enduring wage strike. Lonmin then sought to reduce its liability where possible by instructing non-striking employees to take their accumulated leave and thereafter statutory leave where possible. This meant that people who could assist in collection of relevant documentation were not available to do so. And there was a whole list of complications then. I don't want to read it all, but that was the debate between counsel in an endeavour to come to assist in providing this documentation. We captured the highlights, although there are many, of the difficulties we experienced, and what we said at that stage was that we're not, to use a colloquialism again, kicking for touch. We're doing our best to assist. But speaking for myself, my accent was the whole time on Phase 1. That is the phase with which we're dealing. That is the phase coming up in the very near future. This is the first time in 2 years that Lonmin has an opportunity, with reference to the witness statements file, to produce its case to the Commission. That takes most of our time. And that's where we concentrate on. So against that backdrop, and I don't want to waste more time on this, we say it's unfortunate to now see criticism in the interim report on the corporation. And, Chair, if you look at the glossary to that interim report, it is made up of Lonmin documentation and interviews with witnesses. I have not had time to look at any great detail, but I haven't seen DMR documentation.
There's quite extensive DMR documentation as well.
Then I stand to be corrected. Can I just look at that annexure so that I don't do anybody a disservice? That you'll find in quadruple N2 from page 61 through to 65. And I don't want to go through it. You will, if you are so advised, Chair and Commissioners, look at that. But we would think this is substantially documentation coming from Lonmin and assistance received from Lonmin. Let me deal with the first point, the first of the 3 points I would like to address you on, and that is your mandate, sir. We addressed this in our letter from paragraph 4.2 to 4.7. Perhaps I can take it from 4.2 to 4.7 of quadruple N1. In fact, I should pick it up from 4.1, and this is a quote from your mandate. That's really the starting point. Our learned friends have put some accent on 1.1.3, which we quote, whether it, that's Lonmin, by act or omission, created an environment which was conducive to the creation of tension, labor unrest, disunity amongst its employees, or other harmful conduct. But one can't read that in isolation. You have to read it with the introductory paragraph, which we quote in 4.2. This is all in a causal context of the tragedy. That's the question being posed. This is not an unfair dismissal inquiry, where you have an employee who says, I've been unfairly dismissed, and the inquiry now is, did he have proper housing, did he have sanitation, was his water clean, and was the... This is an inquiry into death. And what the state president says to the commission is, people died, 44 people died. Will you inquire in the context of these deaths into 1.1.3? You, with respect, don't have a mandate, Commission, to inquire whether these omissions might have led to cars being burned at Lonmin, because there's no suggestion of that happening, of people picking up a dispute between two trade unions. There's just no factual basis for that. It was never probed. Of one trade union shooting at the representatives of others or at people non-unionized. Not been asked. This does not cover you to inquire on that tragic death on the Tuesday when the body is found at the Koppie, lying there, as whether this was contributed because of the housing provided by Lonmin. That's not the inquiry. There must be a causal link. So it's, with respect, quite wrong to suggest that you, and in this narrow one, can also pick a few extra subjects. You can pick microlending, especially the bank by NUM. You can't do that, with respect. That's not your mandate. Or senior people's shareholding, or BEE payments made. We have now for 2 years listened to this commission. I have not heard one injured party, or one family member, or one trade unionist suggesting that housing caused the shooting. I would have cross-examined him on that, but I haven't heard that. So to suggest we should read 1.1.3 and have the answer is, with respect, we submit, not correct. What is also not covered here, with respect, Chair and Commissioners, is whether Lonmin complied with its SLP obligations. That's not within your domain. The Chamber of Mines and the DMR can inquire into that in due course. In fact, you will see how this is addressed in the interim report. Quite surprisingly, in the interim report, quadruple N2 at page 52, the Gordian knot is simply cut. And the author says in the second sentence, the living conditions of Lonmin migrant workers must have contributed to the alienation. Well, firstly, you don't inquire into an alienation, but that is assuming an axiom which I haven't heard any.
The paragraph does go on to say, having made the point you quote, that the living conditions of Lonmin's migrant workers must have contributed to that alienation.
Yes.
Then they go on to say, as described in the report, lived experience, etc., the bulk of Lonmin's migrant labourers live either in unacceptable single-sex hostel accommodation or in shacks and informal settlements which do not have access to proper municipal services. Then he goes on. The need to address mine worker living conditions in order to achieve labour peace has been recognised in the Platinum Wage Agreement, which includes the establishment of a joint task team.
Yes.
The point they're making, whether it's a good point or a bad point, is something we may have to decide if we are against you on the point you're arguing at the moment. But the point they're making is not simply confined to the single sentence which you've quoted, which is the second sentence of the paragraph. It follows on that the fact that these people live in unacceptable accommodation or in shacks without proper access to services and so on is relevant in regard to the point made in the next sentence, dealing with the need to address mine worker living conditions in order to achieve labour peace.
We
Whether that's a good point or a bad point.
We accept that 100%.
Well,
That's
you
why.
can't just say that. You can't just say the point they make is confined to the second sentence of the paragraph. You've got to read the whole paragraph. That's the only point I'm making to you.
No, but with respect, the point I make is simply that there's no causal connection established. It's no good to say adverse living conditions, which is common cause between us and our colleagues. This must have contributed to the killing. I say that's a startling proposition. That's what you're inquiring into.
This book's called Labour Peace in a General Sense.
Can I read on that same page, Chair, just after the quote from the London Lonman Director of Corporate Affairs. The report then goes on. The social and labour plans adopted by Lonman in its application for the conversion of old order mineral rights held by Eastern Platinum and Western Platinum were designed in part to address the housing needs of Lonman migrant workers and, if properly implemented, now would probably have produced a less alienated workforce by August 2012. Now, I have not heard that evidence from anybody. Nobody has suggested that. No worker of Lonman has come here to say, I was alienated because I was living in a shack. He comes here and says, I didn't get enough pay. He comes here, he says, I may differ from him, but he says, the people won't talk to me. I come here because NUM shoots at me. I haven't heard a whisper about living conditions making them angry or marching in an illegal march. But this conclusion is simply drawn in the interim report.
Mr. Berger, I'm sorry to interrupt you, Mr. Berger. Being suggested to me it would be appropriate for us to take the tea adjournment now.
I see.
If you want to round off the point before
Yes,
we do
if
so,
I may just round.
then we'll take the tea adjournment and then you can
Now,
continue
let me just say this. If I say that no evidence was led, I don't mean it as a criticism. The explanation for that is we're dealing with phase one. We agree that phase one is being inquired into in the context as you've ruled, sir. So I wouldn't have expected this evidence to be led. All I say is, and I'm going to deal with this on fairness, Lonman cannot now be expected to be put on our guards and start running a case which for 2 years was not on the table. But perhaps after tea, that's the debate.
adjournment now.
Becoming